Have you ever seen a physician, chiropractor, nurse, physiotherapist, or any other healthcare provider for a health concern? My guess is that if you're watching this video, you probably have. If so, it is crucial for you to understand your rights surrounding informed consent. In this video, I will be discussing the case of Reid v. Maloney, which highlights the importance of proper informed consent. The case of Reid v. Maloney is from Alberta in 2010. On February 15, 2000, Mrs. Reid hurt her back playing with her grandchild. Her pain was persistent, and she had previously undergone 2 lower back surgeries. On March 9, 2000, she visited chiropractor Dr. Maloney for treatment of her lower back pain radiating into her left leg. She returned the following 2 days for follow-up treatments. Mrs. Reid's back felt better after the first visit, but then a new negative symptom appeared that night. Her back became significantly worse after the second visit, and then the pain intensified profoundly and moved from her left side to her right side. She also experienced sensory changes and could not walk properly. After the third visit, she worsened and her pain level, which had been at a 5 out of 10, surged to a 10 out of 10. She ultimately went to a hospital emergency ward where she was diagnosed with a herniated disc in her lower back and underwent 2 surgeries. In the initial lawsuit that was heard by the Court of the Queen's Bench of Alberta, Mrs. Reid sued Dr. Maloney, alleging that his treatment had caused or contributed to her back injury. She alleged that he had breached the appropriate standard of care by failing to properly diagnose her, failing to obtain her consent to the treatment, and failing to properly treat her. The trial judge concluded that Dr. Maloney owed his patient a duty of care and that the standard of care was the degree of care, diligence, judgment, and skill to be exercised by a normal, prudent, or reasonable chiropractor under similar circumstances and with the same experience and training. Ultimately, the trial judge concluded that Dr. Maloney failed to obtain informed consent for treatment, giving Mrs. Reid insufficient information about the treatment proposed and failed to advise her of its risks. She also concluded that Dr. Maloney breached the standard of care by beginning treatment before adequately determining Mrs. Reid's condition and making a proper diagnosis. She concluded that given the patient's history and her presenting symptoms, it was of the utmost importance to rule out discal involvement before beginning treatment, and this had not been done. As a result of Dr. Maloney's negligent care, damages of $250,000 were awarded to Mrs. Reid. Dr. Maloney appealed this decision, which was heard by the Court of Appeals of Alberta. The first reason for his appeal was that the trial judge applied an incorrect standard to disclosure requirements in chiropractic care. Put simply, Dr. Maloney asserts that the 2 trial decisions of the Court of Queen's Bench stand for the legal proposition that where a receptionist provides a patient with a consent form and advises the patient to sign, in the absence of any questions, that the standard of care has been met. The Court of Appeals disagrees, stating that whether informed consent has been obtained is fact-based. Legal precedents are for law, not facts, and under the circumstances presented to the trial judge, no error was found in her conclusion. The second reason for Dr. Maloney's appeal is that he claims the trial judge erred by finding that Mrs. Reid would not have consented to the treatment. Mrs. Reid testified that had she known what Dr. Maloney proposed to do, she would have insisted on a further discussion. The trial judge reviewed all evidence on these points and preferred Mrs. Reid's evidence. Dr. Maloney's evidence was based on his standard practice. He argued that he would have explained things to her, and he did not testify as to what he invariably did. The trial judge concluded it is certainly possible that he did not follow his habitual practice. Additionally, Mrs. Reid testified that there was no discussion about applying pressure to her spine, only to her hip bones. The third finding Dr. Maloney appealed was the finding of negligence for not ruling out disc involvement prior to treatment. The trial judge held that on the evidence of 2 experts in a cross-examination, where a chiropractor intends to treat a patient by manipulating their spine, the duty of reasonable care extends beyond merely making a provisional diagnosis. Where a chiropractor intends to actively treat a patient using spinal manipulative therapy, and where a patient has a history of discal back surgery, a chiropractor has a duty to rule out disc problems as a reason for the symptoms presented by the patient, because of the risk of the harm to the patient. At the time, Dr. Reid had no information at all, excluding a brief history and old surgical scars at the relevant place. The final reason for Dr. Maloney's appeal was that the trial judge erred by relying solely on statistical evidence in her causation analysis. Specifically, he argued that the analysis was built upon a misapprehension of facts and the drawing of improper inferences. The trial judge found that the treatment of March 10th was the cause of the respondent's sequestered disc and that the treatment of March 13th likely exacerbated the already existing extruded disc. The expert testimony that was heard outlined several factors to be considered in assessing the cause of disc injury, including the temporal connection between the precipitating event and the injury, a consideration of the symptoms or absence thereof before and after the event, the nature of the event, and other considerations of the patient that might contribute to the injury. The trial judge considered all these factors. More importantly, however, the suggestion that she only or improperly relied on statistical evidence could not be sustained. For these reasons, the Court of Appeals disagreed, and ultimately, the court ruled that the appeal had to be dismissed. This case is important as it can impact individuals seeking chiropractic care and really any health care at all. Firstly, patients should understand that it is okay and even necessary at times to ask questions or be skeptical. As an individual seeking care, you know yourself much better than the healthcare provider does. So ask questions, make sure you tell them your full medical history, and don't be afraid to be skeptical. Because as a patient, you have the right to fully understand what is happening in your treatment. Additionally, this case highlights the fact that informed consent is fact-based and that simply signing a consent form does not necessarily imply consent throughout the entire treatment process. This last point impacts the healthcare system as a whole, which is evident in the improvements that have been made surrounding informed consent since the case of Reid v. Maloney. The College of Chiropractors of Alberta actually highlights this in their advice to the profession section. They say that informed consent is a progressing concept in practice and is adapting to support patients. How a chiropractor practiced informed consent 10 years ago looks different than how informed consent is practiced today. However, the principles of competent informed consent are consistent. It is reasonable that the chiropractors maintain and enhance their competence and may need to acquire new knowledge or skills and change attitudes to perform informed consent to the expectations of patients. Some of the changes that are evident can even be found in the CCOA guidelines for informed consent regarding treatment recommendations. Specifically, the CCOA mentions that chiropractors must obtain written informed consent when a new or changed treatment recommendation is made, and that if patients raise new complaints throughout the course of treatment, the chiropractor must consider the complaint, complete a history and examination, providing a diagnosis before making a treatment recommendation. In the case of Reid v. Maloney, when Mrs. Reid's pain worsened after the initial visit, Dr. Maloney did not do this. Ultimately, this case and the improvements in informed consent have the potential to change the power dynamic in the patient-provider relationship by creating an environment that promotes a collaborative treatment plan in which the provider works with the patient rather than simply telling the patient what to do. And furthermore, this ensures that the patient is comfortable, informed, and understands the care that they are receiving.